Good afternoon. It is Thursday, June 4th, 2026. We're here in case number 26-90447 QVC Group. Why don't we get appearances in the courtroom
by AI,
and then we'll get appearances online, and then I'm going to mute the conference call. All right. Mr. Sussberg, good morning. Afternoon.
Good afternoon, Your Honor. Good to be here. Good to see you. Joshua Sussberg from Kirkland & Ellis on behalf of the debtors, joined by several of my colleagues, many of whom you'll hear from today. Thank you.
Good afternoon, Your Honor. Andrew Glenn, Ager, Bergman & Fuentes, also joined by several of my colleagues, which you will hear from today on behalf of the preferred shareholders. Thank you.
Any other appearances? Ms. Whitworth?
Good afternoon, Judge Pettis. Jana Whitworth for the U.S. Trustee.
All right. Any other appearances in the courtroom? All right. Any other appearances online? All right. Anyone wish to make an appearance online? Okay. I'm going to go ahead and activate the hand-raising feature. Please hit 5* if you want to be unmuted.
conference muted.
All right. Mr. Sussberg?
One second, Your Honor. What do I do? Thank you, Your Honor. Again, for the record, Josh Sussberg from Kirkland & Ellis on behalf of the debtors. We had talked in colloquy a couple weeks ago on a status conference with Mr. Glenn about the proceedings, openings, and the like. Mr. Glenn had reserved the right to seek an opening. He had an empty holster. He was hoping to find some smoking guns to fill it. We've seen his weapons, but he still wants to do an opening, and obviously I can't help myself. So we're going to do a brief opening. But I am going to keep it very brief, and I want to highlight what you're going to see and what you're going to hear so we can contextualize it, because I think that's important. Interestingly enough, Your Honor, I was reading the massive paper that we buried you with last night, and I saw in Mr. Glenn's original objection to exclusivity something really interesting. He said the preferred shareholders vigorously dispute, and I'm quoting lucky paragraph 13, the alleged intercompany claims. Among other things, it's a statement of fact, QVC was a solvent company at the time of the 2022 cash management plan. QVC remained solvent for many years thereafter. Now, presumably, he's relying upon his experts, and that's fine, and we're going to pressure test that testimony today. But I did want to comment, because I do think it's interesting. As I mentioned, one of our witnesses, who I introduced you to at the first day hearing, Mr. Wofford, he's the chief financial officer of the companies. Mr. Wofford and I go back a long time. He was the chief financial officer of JCPenney. He was hired at QVC not only for his good looks, but also for his experience. He had been through a restructuring. He has been through many liability management initiatives, and it would not surprise you, as most of the restructuring professionals in this world know, we have tracking lists, and we're looking at companies. Mr. Wofford landed at QVC in March of 2023, and I had a conversation with him. I went back and looked last night on May 9th, 2023, to see if we could be helpful. Now, ultimately, we did not get engaged for another year or so, maybe a year and a half, but it was unquestionable that QVC as a company was dealing with troubles and had a mountain of debt. And so for someone to say unequivocally that this company was solvent at this point in time, at that point in time, or 5 years ago, is unequivocally false. And in fact, interestingly enough, I wasn't the only restructuring professional in the world that was out there tracking this company. Turns out that Mr. Glenn's expert was tracking it too. Mr. Glenn's expert from FTI, Andy Scruton, he's going to testify to the solvency of the company in 22, 23, and 24. And interestingly enough, FTI did a presentation to Corte Retail, the former name, October 2022, talking about all the business challenges and poor headwinds facing this company, executional weakness, global macroeconomic shifts that are destroying pressures and putting pressure on sales and margin. It goes on and on and on. It was a pitch to provide turnaround services. So again, in the context of the next several days, we're going to pressure test exactly what is meant by solvency. and we're going to figure that out. I want to walk through a couple of things to level set, Your Honor, most of which you're well aware of. We're going to go through 9 witnesses on the company side, and we are going to talk about a process that resulted in an intercompany settlement amongst 4 different boxes with 4 sets of fiduciaries, 2 at each, and separate law firms that were retained to analyze, negotiate, ultimately resolve or litigate potential claims that exist up and down this capital structure. The evidence will demonstrate unequivocally that these conversations and negotiations were done at an arm's length basis in good faith and ultimately resulted in an intercompany settlement that is consistent with the legal factors that we suggest apply or that will apply in any case, and I'll get to that in a minute. At play during the course of confirmation will be many different intercompany claims. Now, it's interesting because we've been hearing from Mr. Glenn, we heard from Mr. Brody, we heard from Mr. Stark. Never before have these intercompany claims been disclosed. Never. We're attaching Qs and Ks and all sorts of information. Mr. Glenn's brief had 600 pages of exhibits of Qs and Ks. Well, we've read those Qs and Ks too. Intercompany claims, as all restructuring professionals know, arise when we get involved. They arise because we start looking at the intercompany relationships that potentially give rise to issues, complaints, and concerns that our stakeholders are going to raise. And guess what? Fraudulent transfer claims, you know when they arise? On the day you file for bankruptcy. They don't otherwise exist. So it would be unbelievable in our world to have companies that are solvent, insolvent, whatever it may be, hypothesize that down the road we want to make sure that you understand if people want to argue about this, we may have a fraudulent transfer. But we're not in bankruptcy, doesn't exist, but that's the case. Well, that's exactly what we did. We looked at all these intercompany claims, all of which are disclosed in those very Qs and Ks that Mr. Glenn attached to his brief. We talked about the tax sharing of payment. We talked about the $800 million that was distributed upstairs in the cash management plan. Now, that cash management plan is a real misnomer. It was a plan to move cash upstairs to the holding company and to Linta in anticipation of a potential covenant default, which would have limited the ability to make distributions out of QVC. And that was in 2022, December actually, 2 months after FTI presented to the company on turnaround initiatives. There's $450 million in dividends that went to preferred holders. Now, whether or not Mr. Glenn's clients, who represent 1/3 of the preferred, are recipients of those dollars remains to be unknown. But there are plenty of people that received those dividends over the last several years. And just to contextualize, in 2023, 2024, and Q1 of 2025, we made a quarterly payment of $25 million each time. That's $225 million. I'm no math expert, but I got that right. $225 million in 2023, 2024, and Q1 of 2025 when we got involved and said we can no longer make those payments. $225 million is more than the $170 million of cash that Mr. Glenn claims is his, notwithstanding his structural subordination. As far as Cornerstone is concerned, Your Honor, I want to talk about that for a brief moment. Cornerstone is owned 62% by the holding company and 38% by Linta, that other box. The Linta box wanted nothing to do with Cornerstone. The business was pulled out of our credit facility because it was a drag on overall performance, and we miraculously convinced QVC Inc. to continue operating that business. If Cornerstone's not operated by QVC Inc., the operating company, the synergies that are realized at that business from a UPS shipping standpoint disappear. There is no more Cornerstone if it's not operated by QVC Inc. So you can't just cavalierly say we're going to go market our 62% interest in Cornerstone and see who buys it. I can tell you, I would buy it for the $2 bill that Mr. Reisman gave me last night. That's what it's worth. As far as governance is concerned, and we've talked about this, Your Honor, and I think this is important. When we got involved, and Ms. Yanamandra spent a lot of time talking about this, when we got involved, there was a holding company board at the box where Mr. Glenn's clients sit, and at the subsidiary boards, as is often the case when restructuring professionals get involved, there were designated employees, many of whom were the same that sat at the holding company board. So when you take a step back, go to the 2022 cash management plan, the dividends in 23 and 24 and 25. The conversations that were happening were with the same people. It's an inherent conflict. It's exactly why we do what we do and put this structure in place. It's the exact opposite of what would happen when someone asks for an entire fairness review, when you have conflicting people on both sides. So what did we do? We did our job. We put in appropriate governance protocols. We put in independent fiduciaries with no interest in these companies, no employment, no stock, nothing. And we asked them, as restructuring professionals with decades of experience, many of whom I'm sure Your Honor's familiar with, to call balls and strikes at their respective boxes. And that's exactly what they did. And they defended their positions, and they pursued their positions. And Mr. Glenn will cite Mr. Cobray's comments in a positional paper that he doesn't believe in the merits of the claims coming back against his box. Of course he said that. Was he going to say, I think we have billions of claims against us, so please, here's more money? Of course not. Everybody took a hard line and a position, and it resulted in months and months and months of diligence and ultimate negotiations. It wasn't one meeting. There were many meetings. There were many iterations, and there were lots of conversations. And again, each box separately managed by these independents, full delegation of authority, all with separate counsel. Did they rely on information from professionals involved in the case? Of course they did. That's always the case. That would be crazy if it wasn't. And the cost would be astronomical, and I would have yet another opportunity to stand here and say why people out there say Chapter 11 is cost prohibitive. We're doing everything we possibly can to feed information, factual information, legal information, whatever it may be, so independent parties with independent counsel can make their own informed decision. That's exactly what happened. And as far as the claims pool is concerned, Your Honor, and again, I'm not a mathematician. I was just thinking about this. We believe there's potentially up to $2 billion of claims that can be alleged up against the holding company. Now, when you take a step back and you think about that, and there's 170 of cash and maybe a little bit of value in Cornerstone, you only have to be right with respect to about 8% of that total claims pool for there to be nothing left at the holding company, setting aside whether or not the preferred holders are entitled to some windfall distribution that came from the operating company in which they're structurally subordinated. And I think that's important to keep in mind because it absolutely helps understand and crystallize the standard at which this is going to be explored. And that's Bankruptcy Rule 9019. And I don't need to repeat it to Your Honor. You're well versed with it. You absolutely understand it. And frankly, Mr. Glenn knows that he cannot defeat this settlement under Rule 9019. And as a result, what does he say? Well, I want to talk about errors in process. I want to find footfalls with independent directors. You relied on Evercore to feed information, but also I want the entire fairness standard to apply. And our response to that is, go ahead, apply the entire fairness standard. Look at every case that he cited. Vanderbilt, Ionosphere, LATAM, Foster Mortgage. We satisfy it in spades, over and over and over again, because we did this right. We put the governance in place, separate advisors with legal teams, with the analysis that was needed to wrap something up in a way that made sense. Not because we're trying to adjudicate people's rights in an inappropriate way, not because we're trying to steal value, because it's what made economic sense under the circumstances for a company that I remind everyone, and we're not here to talk about all the great things we did on the first day, we're eliminating $4 billion of indebtedness. We have a structurally subordinated preferred equity holder that's arguing that value that came from the entities below that are eliminating the debt is entitled to a windfall for money that those entities distributed up, and there's no claims. Can't be the case. I want to quickly highlight, for Your Honor, again, to contextualize some of these tax claims, as well as the cash management plan, because there's going to be a lot of testimony about it, and frankly, it's confusing and it goes all over the place. The simplest way to understand this tax claim is $500 million was overpaid by QVC Inc. upstairs to the parent company. There's a tax sharing agreement, and it's a consolidated group. And the way it would work is QVC, they'd work with their auditors, and you're going to hear the testimony, and they would come up with a number, an estimate, that would be provided for them on a standalone basis, but they'd send it to the holding company to make the ultimate tax payments. Tax sharing agreement is silent on what happens if I paid $10 and the tax was only $8. As a result, $500 million of excess tax payments were made by QVC Inc. upstairs to the holding company in just the last few recent years. Now, Mr. Glenn's argument is the contract stands, the contract says what it says, there's no provision on who gets to recover it. Well, guess what? Contracts get challenged all the time because transfers were made at a time where a company was insolvent. And that is borne under 547. And there's very much a possibility and a claim that the company was insolvent at a time when an overpayment was made for the benefit of the holding company for which they provided no value. And that could be challenged, and that's $500 million. Next, and these are complicated, and I wanted to distill it down. I needed all the incredible smart people at Kirkland to distill it down for me because I was having trouble. There's a deferred tax liability associated with the Linta debt. In order to get favorable tax treatment and beneficial rates, we deferred that tax payment all throughout the course of time. And at one point in time, there's a reckoning. Well, that reckoning is going to be some point in the future. And why is there going to be a reckoning? Because the tax becomes due, or it argued it becomes due, when the debt is discharged. Now, we think that this bankruptcy and the discharge of the Linta debt will absolve the tax liability. But there is real question. There's a real question. Do we have opinions? Yes, we have should opinions. But we all know about opinions. You're going to get a lot of opinions in the next couple of days in this courtroom. From us, from them. You have to weigh them. People sometimes say things that they really don't even understand. And you're going to see that clear and center. So not only do we just have an opinion, but we went out and we bought insurance. Okay? Inc. spent $36 million to procure $925 million of insurance in the event that in a year, 2 years, 3 years, who knows, the IRS comes back and says, you owe this amount of money. And why did Inc. bear that risk? Because everybody is on the hook together. And Inc. has the most value down at the operating company. Holding company's got $170 million of cash. They're going to look to Inc. for any balance and any difference. And the possibility with accruals and interest and other claims that may be associated with this far exceed the insurance coverage. We looked to get more insurance. It was prohibitively cost expensive. But this claim could be up to $2 billion, and that's the figures we note. 500 to 800 million with the possibility of further increasing over $1 billion. And again, all of these entities are joint and several. So to the extent that QVC Inc. gets dinged by the IRS for that claim, they're looking upstairs at the $170 million. So Mr. Glenn's alternative plan is no alternative. That money's going to sit in escrow until there's a final non-appealable order resolving this very issue. That could be years. Finally, I mentioned it before, and I just want to cover it again. You know, the cash management plan that was done late 22. This was a pure plan to move funds to support future dividends and distributions on the eve of a potential inability to test a covenant under the OPCO credit agreement that may have been tripped and eliminated the ability to distribute those funds. It is without question that there are concerns about the company's solvency. 24, 23, 22, 21, I don't know how far back you go. But $800 million was released at the very end of 22, not to mention the $225 million of pref payments in 23, 24, 25. These are live, actionable disputes. And simply sitting here and saying company was solvent in 22 does not answer that question. In fact, it's quite the opposite, because that's exactly what goes into the analysis that we do in evaluating whether a settlement makes sense under 9019. It's probability shifting and probability weighting. And you don't need solvency opinions. You would need a solvency opinion each and every single day for the last 8 years to measure each and every single transaction. It's analyzing in totality the circumstances, the events, the company's performance, and then figuring out, based upon cost and everything else involved, does this make sense based on all of the circumstances? So finally, Your Honor, I did tell you I'd be brief. I think I've been brief. Mr. Glenn is going to talk about the TOPCO fiduciaries exercising a fiduciary out. They should exercise their fiduciary out, and we should go pursue the TOPCO-only plan. And we're going to take the $170 million, and we're going to go market a part of a company that we don't even know if it's operating, and you should exercise your out. And those directors have separate counsel, and you'll hear from them. They said that's a fiduciary out to nowhere, and it absolutely is. If this plan is not confirmed, and this isn't as a threat or just anything to anyone, this is just the reality. If the plan is not confirmed, the intercompany settlement in totality fails. We have to go figure out how we're going to address the holdco, which clearly has a lot more issues that are articulated in the exclusivity objection and the related plan. We're going to have to go figure out what happens with Cornerstone and if anybody even wants to entertain operating it. And you're going to hear from witnesses on this very point. And we're going to have to go figure out how we reorganize the rest and put all sorts of money in reserve in case the tax man comes calling and we have to deal with that liability. And we'll do that. But I don't think we have to, Your Honor. I don't think we have to because we did this right. And while I did not anticipate having Mr. Glenn here today at confirmation, I did anticipate these very issues. And we collectively worked to make sure that we dotted our I's and we crossed our T's and we ran a process from a governance standpoint, from a stakeholder standpoint, that made imminent and reasonable sense. We will demonstrate that we satisfy each and every single one of the 1129A factors, including 1129A10, where they've tried to create a lot of confusion, but they miss the really big point on Container Store, which is from this district, which is settlement consideration results in unimpairment. And so it's not applicable. But we satisfy it anyway. And, Your Honor, I will tell you that this intercompany settlement, no matter what you hear, was appropriately negotiated, evaluated, and ultimately entered into. It makes the most sense for these estates, and we look forward to seeking confirmation of our plan. Thank you, Your Honor.
Thank you. Turn your camera on real quick, just so I can find you. Oh, you get him? You got him? Okay, you're there. I got you. But then my went away. I think. Huh? Okay.
It's not giving me the option to share. Does it even come back?
No. He's controlling it. Are you sharing directly or through GoToMeeting?
I was going to do it through GoToMeetings.
Okay. Well then, yeah, give it back to me. Right. Okay. Turn your cam. Okay, there you are.
All right. All right. Thank you, Your Honor. Again, Andrew Glenn, Glenn Ager, Bergman, and Fuentes. This case is not about Mr. Sussberg, and it's not about me. This case is about whether the QVC Group plan of reorganization should be confirmed. Not any subsidiary companies. This is not about other creditors of our estate. There's no opposition to any of the subsidiary plans, so we're here because of what's happening with QVC Group. So I'd like to run through what is going on with QVC Group. Just next one. This is what the evidence will show. Here's some very brief background on QVC Group. QVC Group has $9.5 million of priority tax claims. They are ahead of us. They're ahead of the general unsecured creditors. It has $1.1 million of general unsecured claims, but that includes approximately $880,000 of director compensation. So what we're talking about is true gut claims at QVC Group are in the low hundreds of thousands of dollars, $250,000, something of that ilk. But it also has $1.4 billion of preferred stock and no funded debt at all. So you can change the slide. So we asked the company to provide us with a breakdown of these claims, and that's what we have on Your Honor's screen. And we have a bunch of service providers, some of whom have already been paid in small amounts. That's the top section, and you can see the priority status is general unsecured claim. That's the company's assessment of those claims. You see the director compensation right below that. Again, those are general unsecured claims, but they're insider claims. And then you have the tax claims below, which comprise the vast majority of the general unsecured claims at QVC Group. Now, those tax claims are ahead of this alleged intercompany claim. So we could turn to the next slide, please. So what is the asset base at QVC Group? We have $195 million in cash, and that number seems to be moving, but it's in that category. The 62% of the equity in Cornerstone, a controlling interest in that company, and you're going to hear a lot about that and what's happening in the plan and how it's unexplained. But what's very interesting is that there's also a $62 million intercompany account receivable. Now, that receivable is a claim that we have against the subsidiary companies that doesn't seem to be accounted for anywhere and raises serious concerns about how this process has unfolded. On the right, you see the equity diagram showing ownership of this Cornerstone business. Now, if we turn to the next slide, please, we get to our recovery analysis. And this analysis is illustrative. But what it tells Your Honor is that if we value the enterprise value of Cornerstone, our 62% interest, at their valuation, which we believe is undervalued, Your Honor, we take the cash, we take this refund, this account receivable of $62 million, which I'm going to talk about, there's $330 million of distributable value at our box, and that would result in approximately $26 per share for the preferred shareholders. Now, this is how the waterfall would work if this intercompany claim did not exist. And so I told Your Honor this at one of the last hearings. This is really a tug of war between the preferred shareholders of QVC Group and the creditors of QVC Inc. So let's go to the next slide and talk about the evidence. And the next slide, please. So we have here, and this is well-established law, which Your Honor I know is very familiar with, the standards for the settlement of this type, 9019. And we believe the evidence will show, Your Honor, that absolutely none of these factors have been satisfied. Now, Mr. Sussberg would have you say, well, you know, we have disinterested directors, it's game over because it's their business judgment. That is just simply not true. Your Honor has a critical role in this process to determine whether these standards are met, irrespective of whether these supposedly independent directors believe that. Now, we believe, Your Honor, that this intercompany settlement cannot be approved. Next slide, please. This is vitally important, Your Honor. QVC Inc. is getting more than 100% of what it could get in an actual litigation. It's getting 100% of our assets without having to spend a dollar on litigation. So what that means is if we had to defend the claim, there would be, call it $30 million of defense costs. They would have, illustratively, $30 million of costs for them. So that's a $60 million decrement on the net that they would get if this were litigated, and they won. They're getting more than that. There's no credit back to us for any of those costs. Even more importantly from our perspective, the special committee whose fiduciary duty was to protect us as the residual stakeholder of these amounts made no probability assessment of the claims themselves. They negotiated for no deduction for litigation costs. So what happens here is that QVC Group is getting 0% of what it could get in an actual litigation. This is the worst possible outcome for QVC Group and forfeits any chance of success in the litigation. And I think this is vitally important. All preferred shareholders who were before the court oppose this. No one has stood up and said, hey, I like this release. I like this deal. Everybody opposes it. So Rule 9019 has a very, very important phrase. It says you can approve a settlement or a compromise. This is not a compromise. It's a complete capitulation because there's nothing left for us. Next slide, please. So how did this come together? The debtors engaged in negotiations before this bankruptcy for these intercompany claims. And there were negotiations with Linta, a subsidiary you're going to hear a lot about, and there were negotiations with QVC Group, which is our debtor. Now, what we see here is stakeholder representation. Stakeholder representation clearly matters as a matter of fact and as a matter of outcome here. We have the QVC Inc. bondholders, represented by Davis Polk and PJT in the negotiations. We have the revolving credit lenders, represented by Simpson Thatcher and Lazard. And we applauded Aiken, and we applauded Centerview in our papers. They represented the Linta bondholders. Let's see what happened with them. But what we know, they're getting a very significant recovery. But there was no one representing the QVCG stakeholders in this supposed negotiation. And what you're going to see is that the outcome matters because there was no representation. Next slide, please. Okay, no, we're good. This deck, Your Honor, which is in evidence, is a deck prepared by the QVC Inc. Special Committee, represented by Catton. They sent this presentation to Milbank, representing the directors of Linta, and Cobra and Kim, representing the Special Committee of our debtors. And this is their worldview about these purported claims. Now, next slide, please. What are the claims? They are alleged, unfiled, undisclosed fraudulent conveyance claims for dividends going back to 22 and 2023, where they got contemporaneous solvency opinions allowing those transactions to happen. There are alleged tax indemnity claims that the debtors have publicly stated in SEC filings that will likely never occur, and that position is supported by a robust PwC tax opinion, and that position is supported by $925 million of insurance. $925 million of insurance for this very risk that they're charging us $400 million. They got insurers to insure that risk for $36 million. There are claims for alleged overpayments under the tax sharing agreement. Mr. Sussberg alluded to those. But you're going to hear from the company's tax professionals who have testified and will testify again that the amounts that were paid were fully consistent with the tax sharing agreement. And the tax sharing agreement dates all the way back to 2004. There's absolutely no basis under fraudulent conveyance law to reach back that far. And Mr. Wofford, we expect, will testify that he never even heard about these claims until after the bankruptcy was filed, even though he's the company's CFO. Next slide, please. So here's the outcome. Here's the outcome, and here's the difference between real arm's-length negotiations with stakeholder representation. You have on our box on the right, what are the documented intercompany claims? $0. On Linta, you have a promissory note, a written note for $1.8 billion. And then you have threatened claims of $2.1 billion against Linta, and you have $1 to $3 billion against us. What was the outcome here? Linta got paid. Linta got paid $23 million. They walked away, QVCI did, for all of these intercompany claims. They just let them go because there was someone pushing back. In contrast, they gave away for us $350 million of recovery that would otherwise be available to us. Representation by stakeholders matters. Next slide, please. So what does the QVCI independent committee say about this? How did this come to be that these documented intercompany claims, these threatened intercompany claims went away? They valued the claims against Linta at double the amount that they valued against QVCG. Mr. Keglovic, their independent director, testified that, yes, we had a claim of $750 million against Linta and $400 million against Topco. That is correct. And you were seeking more from Linta because you thought there was a stronger claim or one of more value. We evaluated our claim, and that's the conclusion they came to. So even though they were of the view that the claims against Linta were stronger, Linta walked away with a paycheck. Next slide, please. Showing you even further how the playing field was so far tilted against our debtor. QVC Group, the parent company, which Mr. Sussberg says was insolvent, had too much of these intercompany claims. It was insolvent since 2021. That didn't stop the debtors from funding from QVC, I should say, QVCG, from funding $90 million of the restructuring expenses of all the subsidiaries for no value back. The special committee of our debtor did not authorize those payments. They did not supervise the use of that cash. They just let it go. So what the effect of what happened here was, Your Honor, our special committee funded the process, the independent directors of QVCI and their counsel, that allowed them to raid our assets in the negotiations. Think the right way to think of this, starting from these extensions of restructuring expenses, is that the parties believed the QVC Group was their ATM they could withdraw cash for at any point in time. Now, what did the special committee do for our debtor to justify the settlement? Very little. It never received a valuation of the assets, and that's primarily Cornerstone. It ignored proposals from the QVC Inc. stakeholders offering our creditors, or our clients, the preferred shareholders, recovery. It ignored an outreach. During these negotiations, Mr. Brody of the Cleary firm, my co-counsel here, sent the company a letter. And it said, I represent preferred shareholders, please engage with me. They ignored that outreach. They used selective data on solvency from Evercore, who represented all the debtors, and they refused to consider any alternatives to the settlement. Strikingly, even though Mr. Sussberg says that our debtor was insolvent for years, and that our debtor allowed all of these wrongful dividend payments, our special committee never investigated those claims. Our debtor is releasing all of the officers and directors for authorizing those claims, and QVC Inc. is doing the exact same thing. So they have billions of dollars of claims. They've raided our box. They have, if they really believed in these claims, they could sue the parties that authorized them, but they're just letting them go. And they gave away 100% of our value in a very short meeting at the Kirkland & Ellis office. You're going to hear about this quite a bit. Now, this meeting occurred in, I believe, the February 24 timeframe of this year. QVC Inc.'s independent directors and our special committee met in Kirkland's office for approximately 4 hours. The purpose of that meeting was to get a fast and final settlement for QVC Inc. Our debtor's opening position in those negotiations was that it would not allow any portion to be paid for this intercompany claim right before this meeting was held. But what you're going to hear from the independent director of QVC Inc., Mr. Keglovic, that the first and only counteroffer made by our special committee was a complete capitulation. So let's go very briefly into the claims and how they are so weak. This is the February 13th deck that preceded the meeting I've talked about. This is the opening position justifying our special committee's position that the intercompany claim should get nothing. They said the claims against our debtor aren't viable. We don't believe that you, QVC Inc., can make any showing of insolvency. They provided this background information, and they said whatever Evercore provided, which was bond trading prices alone, was insufficient to prove insolvency. We agree with their position. These dividends occurred primarily 3 to 4 years ago, and this is the dividends from QVC Inc. up to QVC Group. Mr. Sussberg blurred over this issue. There were dividends to our clients, the preferred shareholders, after the 22 and 2023 timeframe, but that was with cash that was already in our box. The transfers that are the dividends from QVC Inc. up to QVC Group occurred in 2022 and 2023. We've looked. It might exist. Who knows? But there doesn't appear to be any significant precedent for a successful fraudulent conveyance challenge dating back so far where a party got a solvency opinion contemporaneously. And we do know with certainty that settling an unfiled fraudulent conveyance claim for 100% of the value that's available in a matter of hours is totally unprecedented. Next. So Duff and Phelps provided these solvency opinions using the standard tests that are admitted in this court, but the special committee never reached out to them, never performed any solvency analysis of its own, questioned solvency solely based on bond trading prices, and effectively conceded insolvency without a fight. Next slide. On the tax claims. QVC Inc. alleged that it overpaid for tax liabilities. But Mr. Kearns will testify that that's just not true. And that any claim that we have somehow taken tax attributes from the subsidiary company is completely meritless. The real event is what Mr. Sussberg said about this deferred tax liability. Next slide, please. So what QVC Inc. is saying is you need to indemnify us because we're jointly and severally liable for this deferred tax liability, and you need to pay us for that. But when these negotiations had occurred, the debtors already received the tax opinion from PwC showing a very high degree of certainty that the tax would never become payable, and they had already obtained this insurance coverage that implied that the risk of this tax ever happening was around 3.8%. The negotiation documents showed that what QVC Inc. was actually asking for was for QVC Group to pay the insurance premium for that. But instead of paying a $36 million insurance premium, we paid $400 million, or $350. We'll see what the number ultimately is. Next slide, please. So February 22nd of 2026, this is 10 days after Cobre sends the first presentation showing how weak the claims are. Catton, representing QVC Inc., sends this term sheet, and it says two things. It says, we're going to get a $400 million unsecured claim against Topco. That's exactly what happened. And that the holders of preferred shares shall receive no recovery at all. The meeting is then held on February 24th of 2026. What happens at that meeting? Capitulation. This is the document showing the capitulation. There's nothing preceding this. Because while we see a request to reduce that number, that intercompany claim to $350 million, the more important thing is what's beneath it. The preferred gets nothing. So basically, this number is ethereal. It doesn't matter because the real goal is for us to get nothing and for them to grab everything that's there. That happened on February 24th. So we go from, we're going to give you a $350 million claim for you to take everything, and then we're going to give you a $400 million claim for you to get everything. Either way, you get everything. Now, what didn't the special committee do in these negotiations? It never made a threat to actually litigate the claim. There was no time sensitivity for QVC Group. In fact, the opposite was true. QVC Inc. wanted to do a pre-pack, and QVC Group could have said, no, you're not going to do a pre-pack with us. We're not going to go along with you doing a pre-pack. We're going to fight you. We're going to use our leverage, which is just what Linta did with its independent directors and the Aiken Gump firm. There was no financial distress for QVC Inc., right? There's no funded debt. They could have paid all these claims in cash if they wanted to. That's not the point. They capitulated. They negotiated, and they're going to testify this to this effect, Your Honor, that they claim they had no leverage and that they had insufficient litigation funding. They were out-resourced, is what Mr. Meltzer will say, because they had $200 million and the majority stake in Cornerstone. I think there are a lot of lawyers in this room that would say, I can litigate this case for much less than $200 million and get you to the finish line. That's why this was not an arm's-length negotiation. Next slide. Mr. Meltzer, our independent director, knew that our cash was being used for subsidiary restructuring costs, but was unaware of the amount of the terms. He never got an estimate of QVCG's litigation costs. He didn't even know whether his counsel ever told QVC Inc. Special Committee that the claims were not even likely to be viable. He ignored the outreach I described from Mr. Brody. He never attempted to reach out to any stakeholders, whether they're unsecured creditors or preferred shareholders. And he never insisted and put his foot down that you have to leave something behind for the preferred shareholders. So I asked him this question at the deposition on the next slide. I said, I want to ask you about the factors you've considered. Did you come to a view about the probability that QVC Inc. would prevail in this litigation? No. And then he says, in response to my question, well, what about QVCG? Did you ever assess those odds? He said, no, I didn't, in substance. But he says, and this is vitally important, that that litigation would be highly fact-specific and highly litigated, contentious litigation, i.e., there's real stuff to litigate here. We have a point. They have a point. That's a litigation. And that's not warranting this capitulation that's happening here. If he said, we have no defenses, we have no chance of winning, okay, maybe that would be a problem. But he never says that. Now, we see in the pleadings that were just filed that the QVC Special Committee says that this capitulation is somehow terrific. They talk about the virtue of these releases, but they have absolutely no idea whether any of the current preferred shareholders received the dividends, although one of my clients received one and is still here today protesting this. But they're not letting the preferred shareholders vote. We've been completely disenfranchised. So if we are the affected stakeholder from this and they're offering us something, a dividend, shouldn't we be allowed to vote and tell the court, tell our fiduciaries what we, the affected stakeholders, think? I think this process warrants that. I think our bankruptcy code is designed to be democratic. And it's one thing when litigation is hard fought and the company has invested money and the litigation needs to end. But this is very close to substantive consolidation. This is giving up all of our value to a affiliated company and completely disenfranchising us in the process. So you should reject this 1919 settlement because the evidence will show that QVC Inc., our adversary, wanted a fast and final resolution. But fast and final for QVCI, I should say, doesn't mean that it was fair and equitable for QVCG. We're the only party that stood to lose or gain from this litigation. We have gotten no vote. So we get now to confirmation. I've talked about the 1919 settlement. That's a cornerstone of the plan, no pun intended. That means this plan must fail because the 1919 settlement should be rejected. But there are other gating issues here. We believe this plan was not proposed in good faith because it gutted us under these highly questionable circumstances and made us a sacrificial lamb for other debtors. And this gating issue, which I still don't understand, which is there's no impaired non-insider accepting class when there are impaired classes, one impaired classes, and that is this intercompany claim. It's allowed at $400 million. But it's getting something very different than $400 million. This came up in the negotiations. The slide in front of you is an email exchange between Davis Polk, representing QVC Inc. stakeholders, and Kirkland. And Davis Polk asks, I'm checking in with you on your thoughts on the pre-pack. For Topco, I think where we left off last time was that 1129-810 may not apply, but your team would think through that. In the next slide, the response is, well, in that world, this only works if you have this intercompany settlement claim. You don't have any non-consenting impaired classes of claims at Topco. This claim is impaired and is unconfirmable. So the next slide shows you what's happening here and what's so suspicious with Cornerstone. This is the treatment of the intercompany claim in the plan. And what it gives this intercompany claim is all distributable cash in QVC Group. Mr. Sussberg says that's 177. We think it is higher or should be higher. It is what it is. It's certainly not $400 million. What happens with the Cornerstone equity? Is there any disclosure that the Cornerstone equity will be treated, will be paid as a distribution for the settlement claim? There's no distribution mechanic as treatment for that claim in the plan. Instead, we go to the next slide, and we see this restructuring steps plan filed post-petition May 11th of 2026. And this defines some of the mechanics, the plumbing of how the transaction is going to be implemented. What we see on the next slide is the steps for Cornerstone. And it says QVCG will transfer its stock in Cornerstone to Liberty QVC Holding LLC. And then, step B, Liberty QVC Holding transfers the stock to Curate Retail Group. And then, Curate Retail Group transfers the Cornerstone stock to QVC. No one has explained to us why this is happening. No one has explained why QVCI is getting this when it's not a distribution pursuant to the plan. It's just a complete mystery. So there is an alternative to this. We want to have an alternative. And if Your Honor does not confirm this plan as we believe it should not, we would expect this case to be resolved through mediation or a settlement. That's what we want. We're not here. We don't want to litigate for years. We would like a fair resolution of this case. But we're left with no alternative under this current construct. So we've come up with one. We've moved to terminate exclusivity. Our debtor is liquidating, right? There's no restructuring involving our debtor as it now stands. We want the even playing field that Linta had in its negotiations before this case came to the court. We're willing to put money behind it. We're willing to pay these senior claims so they're not caught up into the mix. We didn't know what they were when we first proposed this, but now we see this slide showing what the claims really are, and they're minimal. There's nothing there. And we're also willing to pay for our fair share of this tax insurance, which is what the QVC independent committee asked us to do. Thank you so much for your time. We look forward to presenting our case. Thank you.
Thank you. All right, can both parties please, I'm sorry, go ahead, Ms. Whitworth.
Judge Dana Whitworth, for the record, for the U.S. trustee, I was just going to let the court know, as far as the U.S. trustee's objection is concerned, we worked with the debtor, the objection to confirmation. We worked with the debtor to resolve all of the objections except for our third-party opt-out situation. So,
Thank you. All right, anyone else wish to be heard by way of opening statement? All right, can both parties please file their slides on the record? All right, so I think, today we can go as long as we make sense. Tomorrow we were going to start at 3. Mr. Johnson graciously gave up his 1 o'clock slot, so we can now start at 1 tomorrow. Monday we have all day. And then I'm told that I had Monday we have all day. Tuesday we have starting at 1. It may be that we could be able to start at 10, but that's a question mark. And then I had a trial starting on the 10th, which was supposed to go for 3 days, and it's in mediation, and so depending if that gets resolved, we would have the 10th, not the 11th, but the 12th and the 15th. So we would have basically the 6 days that you all wanted. Mr. McKay?
Your Honor, you just made a lot of people very happy, so thank you. And I say that in part because there have been suggestions, wrongfully, that when we didn't appreciate the NBA Finals calendar when Your Honor decided to go to 8 o'clock tomorrow, and there are a healthy number of New Yorkers in the courtroom.
Understood, and there's a lot of people who also want to catch planes going to New York.
Agreed. Your Honor, as you look over in your courtroom, your right, my left, there's a voluminous number of exhibits. We put all of them on flash drives for you and your staff.
Right. The problem is, I don't know how to use a flash drive, okay? So apparently you have to go to the U.S. Marshal
Oh, really? Oh.
or somebody
Okay.
to get it done. So unfortunately,
You can't accept anything electronic. I understand.
well, I can, but I don't know that I'm going to be able to use it anytime soon.
Fair. We'll see what we can do with the marshals. We're not trying to upload any viruses.
So it's not my rule, but I have to follow it.
I totally respect it. Your Honor entered a 502D order today, I believe, and there was a stipulation. We have worked very closely with Mr. Glenn and his team on that issue. You have heard references to the subject matter of that already.
Right.
That is the PwC opinion. I think we've got guidelines on how we can manage through the process where no one gets into the substance of it, but keeps that at the high level of, in the tax world, what level of opinion it was, who was the, and so on. And so I think we're going to work that out. I do also want to thank Mr. Glenn and his team for working with members of our team on exhibits on a series, like on a daily, if not hourly basis. As you can imagine, very consistent with restructuring litigation. This is an iterative process, and we get follow-ups, and so we are working on that. But my colleague, Mr. Colligan, is going to, I believe, present a largely consensual set of exhibits, some of which are joint, and with lists, so we don't have to do a dramatic reading of numbers into the record to kick things off.
So the person you have to convince is Ms. Hernandez, because she's the keeper of the exhibits.
All right, we will present it, and if you have any questions, if you want more on the record, we'll give you whatever you need. After that, we've had some robust openings. I regret to inform you that the next series of witnesses are accounting and tax related. So if you want to take a break and get some coffee, we're not going to blame anyone. But we have 3 witnesses today that we expect will take the bulk of the day.
All right, good. So does it make sense to do the exhibits now, or does it make sense to do the exhibits then take a short break?
I think if we do the exhibits now and take a short break, I don't think it's going to be more than a few minutes.
Okay.
Thank you, Your Honor.
Okay.
Your Honor, George Colligan for the debtors. As Mr. McCain noted, we have met and conferred with the Glen Agri team over the past several weeks and reached consensus on the exhibits exchanged. We have a few open points that we plan to meet and continue to meet and confer on, and we're tabling those for now, and we can raise any remaining that we haven't resolved through further meet and confers at that time tomorrow. We have prepared a reference sheet for the debtors exhibits that identifies all of the joint exhibits. And then we will reference in our exams DXs. And then that reference that we have available for the court and the Glen Agri team, that will also cross-reference the PXs, which are the preferred shareholders exhibits, and with JXs. So with that, Your Honor.
Almost sounds like plaintiff, defendant, and joint.
Your Honor, we move debtors exhibits 1 through 445 into evidence with the following exceptions, which remain open points. DX 235, expert reports, which on the debtors list include DX 384, DX 386, and Mr. Wofford's deposition transcript, which is DX 438. And then, as was noted by Mr. McCain, we just wanted to highlight that this move to submit them into evidence is subject to the 502D protective order on the docket for DX 402 and 403.
Any objection?
One moment while I talk to the people who know these things much more than me. No objection, Your Honor. Thank you.
So DX 1 through 441?
445, Your Honor.
445, okay.
Thank you, Your Honor.
Mr. Glenn, are you going to put your exhibits in, or just at this time, or are we going to wait?
Your Honor, I think at this point, we actually are going to do it by case in chief,
Okay,
and
that's
rebuttal,
fine,
if that's okay,
fine,
Your Honor?
That's fine.
All right, thank you.
All right. So with that, it is now 2 o'clock. Why don't we come back at 2:15, and we'll go till we get done today.
Appreciate you. Thank you very much.
All right, thank you. And to the extent people need to leave after the openings, feel free to do so.
Thank you, Your Honor.